Hey everyone, welcome to our webinar on structuring your startup for growth and a future exit. My name is Helen Young and I'm a practice leader in LegalVision's tech team. I'm joined today by my colleague Jack Chi, who is an accountant at William Buck. Jack, do you mind giving us a quick summary on William Buck and yourself?
Yeah, thanks, Helen. Hey, everyone. Welcome to the webinar. My name's Jack. I'm an accountant. I'm part of a firm called William Buck, and we're a team of accountants who work with Aussie tech companies from early stage startups all the way to unicorn and exit. So that's our mantra, startup to exit. We come across a lot of these startup specific accounting, tax and finance and grant questions, and look forward to doing this session with you today.
Great, thanks, Jack. So before we begin, just a couple of quick housekeeping items that you can see on the slide. You'll be emailed the webinar recording and slides, so there's no need to take any notes as we go along. Also, please submit your questions in the chat box and we'll answer these at the end. There's also a survey at the end of the webinar. We ask if you can complete the survey. Also, all attendees are eligible to receive a free legal consultation with us to discuss how we can help with your contracts or any of your legal needs. To request your free consultation, please provide us your contact details in the survey that appears at the end of this webinar. So today we'll be discussing some of these topics here that we've listed in the contents page. The first topic is best structures to support your growth. The key benefits of a corporate structure for a startup, a simple, effective and flexible structure, the benefits of implementing the right structure early, and then planning now for a future exit. At the end of the webinar, we'll be answering some of your questions. So please submit your questions throughout the webinar through the chat function and we'll answer them at the end. So let's get started on why you're here. So what is the best structure to support growth in a startup? There are a number of different structures that a startup can put in place. But is there a simple and effective structure that can provide flexibility for growth and eventually an exit? Based on our experience, a corporate structure is the simplest and most effective structure for startups when you're comparing it to a sole trader business or a trust structure. On the next slide, I've listed some of the key benefits of why we have this view. The first point I have here is probably one of the most important reasons, in my view, in having a corporate structure, which is really the ability to access certain grants and concessions that are only available to a company. One of these is the R&D concession, which gives eligible companies a tax offset when conducting eligible R&D activities. Any R&D expenses incurred by the founder before a company is incorporated will not be eligible for the tax offset, which is why it's really important to get the structure right early, which is a topic Jack is going to go through later in the webinar. The other concession that we see startups take advantage of is the early stage innovative company concession, also known as an ESIC. This concession provides eligible sophisticated investors with a maximum tax offset of $200,000 and a modified capital gains tax benefit where capital gain on eligible shares invested in an ESIC is disregarded. These tax benefits can be very attractive to an investor. Having the ability to access grants such as these is a huge advantage for startups and could be the make or break for some, as most startups need initial funding in order to start developing a tech or building a product, whether it's from tax offsets or seed funding from investors. Which brings us to our next point, which is being able to actually attract and bring investors on board in the first place. In our experience, investors generally prefer to invest in a company. For a retail mom and dad investor, it is a very common and easy structure to understand. And for sophisticated investors that are generally experienced enough to know that the company has access to certain grants and concessions and that is a vehicle that is conducive to growth and flexibility, whether it's expanding or going public. A company is generally much more attractive to an investor than a unit trust or partnership structure due to the saleability of shares if the investor was to sell up and make a gain in the future. Most investors also like the protection of limited liability that a company offers. That is, shareholders are generally protected from being personally liable for a company's debt, which is a very key benefit in a company. Another key benefit is being able to have flexibility in the type of interest a company can offer to investors. Most startups don't want to give away a cut of their business until they're much bigger, but they are constrained by the need for funding. Having a company structure gives founders the flexibility to issue other types of equities, such as a safe note or convertible note. A safe note is an agreement that allows investors to buy shares in a future price round at a discount. Convertible notes are essentially a loan that allows investors to convert into shares at a certain trigger point, such as a future capital raise. I should note that the ESA concession that I raised earlier doesn't apply to a safe note or to convertible note, as it only applies to shares. In my next point, I've listed employee share option plans, also known as ESOP. It is a term that is used a lot in the startup world, as most startups don't have the funds to be competitive to retain key employees. So being able to incentivize and motivate such employees by giving ownership interest in the form of options or shares is a huge advantage, particularly if you find an employee that you want to bring on board as a co-owner or has certain skills that you want to keep within your startup. There are also employee share scheme tax concessions for startups that can be taken advantage of, amongst other things, if the company is less than 10 years old. There are other tax efficiencies in a company, which includes a flat corporate tax rate of either 25% or 30%, which is lower than the highest marginal rate for individuals. There's also the ability to use franking credits, which is a type of tax credit sometimes issued to shareholders when eligible companies pay dividends from their after-tax profits. Shareholders can use this franking credit to offset their own tax, which could result in no tax being paid by the shareholder. Lastly, being able to have flexibility in exiting is something that should be considered when planning. Whether that exit plan involves the founder retiring or cashing out to fund a new venture or going public, a corporate structure gives you the flexibility to do this. Something this Jack will cover in his slide when he talks about planning for an exit later on. So on the next slide, I have a diagram here of a common corporate structure that you often see when startups have incorporated without obtaining advice beforehand. In this diagram, you will see an operating company that is wholly owned by the individual founder, with the business operations and assets, such as the IP, held in the company. The company also employs all staff, engages in all third-party contracts, and enters into loan arrangements. Very standard business operations. Now, this is an okay structure and does take advantage of all the benefits that are highlighted in the previous slide. However, it is not an effective asset protection structure. It is a structure that would be suitable for a business that has no intentions of expanding, has no assets of value, or the founder has a very low risk lifestyle, which is probably not the case for many startups. The structure here does not protect the company's assets or IP from third-party claims or liabilities if the company was unable to repay its debt, for example, or if a claim was made to the company. If a claim was made to the company, all risk owned in the company would be, or assets, owned in the company would be at risk, including that tech software or patent you've been developing for the last 2 years. As you can see in the diagram, the shares of the company are owned by the founder personally, which means the shares are not protected from the founder's personal risk or lifestyle. Such risk could mean the shares and ultimately the company itself fall into the hands of a trustee in bankruptcy if the founder was to file for bankruptcy, or into the control of an ex-spouse if there was a marital dispute, or even into the hands of an unintended family member if the founder was to pass away and estate planning hadn't been considered. Lastly, the structure does make it quite difficult to expand efficiently and may require a restructure to happen before you actually start expanding, something Jack will talk more on later on in the webinar. So although this is a corporate structure, there are still inefficiencies. So it leads to the question, what is an efficient and effective corporate structure? So here on the next slide, I've put here a diagram of what we consider to be a simple, effective, and flexible structure. It has the ability to take advantage of all the corporate benefits I discussed earlier, plus overcome the asset protection and expansion hurdles from the previous slide. This dual company structure involves the founder's family trust holding all the shares in a holding company, which wholly owns all the shares in an operating company, or in this example, 2 operating companies. The operating company would continue to hold all business operations, staff, and third-party contracts, whereas here we have the IP and any assets or values sitting in the holding company, protected from any risk or liabilities that could arise from the business, which is sitting in the operating company. This means that all that risk and liability would be contained to that operating entity only. The family trust adds an extra layer of protection to the company, as the personal liabilities and risk of a founder that we discussed earlier would be mitigated, as the founder is no longer holding the shares personally. If you have no intentions to diversify, expand, or have any real need to protect certain IP, then potentially having a family trust without a holding company is also an option to consider, which is basically the structure in the previous slide, but with a family trust replacing the individual founder as a shareholder. There's an alternative. In this diagram on this slide, you can see I have 2 operating companies, which are also called subsidiaries. They're sitting underneath, which is sitting underneath the holding company. The second operating company is an example only to show how this type of structure can also provide founders with the flexibility to expand and grow by setting up multiple subsidiaries, whether it's to diversify the business, have different business ventures, or setting up a different subsidiary in various different locations, whether it's in different states or internationally, or even incorporating an internationally incorporated subsidiary if the business was to go internationally or global. Lastly, the structure opens the door for the group to consolidate for income tax purposes. This means the multiple subsidiaries in the group will be treated as one taxpayer for income tax purposes, easing the burden on lodging multiple tax returns, making intercompany transactions more tax efficient. Tax advantages such as tax losses can also be used across the group. Tax consolidating can also make it easier to access R&D concessions if one entity was to own the R&D and another was to incur the expenses relating to the R&D on the owner's behalf. It is important that you do get advice before consolidating, as doing so could trigger a taxing event, particularly if the group has been operating for a while and consolidation was not considered early in the piece. Which does bring us to the first topic that Jack's going to cover, which is the importance of implementing the right structure early. Thanks, Jack.
Okay, thanks, Helen. So I'm going to talk about the benefits of implementing the right structure early. And I've never read the book, The 7 Habits of Highly Effective People, but I do know that apparently the second habit discussed in the book is the idea of you start with the end in mind. And starting the end in mind is very much something that applies to structuring a startup. Okay, and what's the reason for that? Okay, so if you have the right structure from the start, it avoids you a lot of hassle down the track to get into the right structure from a wrong structure. Okay, so typically if you do end up in the scenario where you need to restructure, and some of the scenarios we can discuss further on in this webinar, the restructure typically involves assets changing hands. Okay, so that could mean shares changing hands, assets changing hands, IP, customer contracts. So basically, and a lot of that involves changing agreements with customers, with suppliers, and you might need to redo employment contracts with employees. So a lot of that stuff is a lot of work, and sometimes it's actually impossible due to whatever commercial or legal reason. So you could be stuck with the wrong structure to some extent, or you could just be doing a lot of work that could have been avoided from the start. Now, a second reason why you start with the end in mind is that as businesses grow, the value of their assets, the value of their business, the value of their shares, that tends to rise over time, which means that the tax man is a serious consideration because, like I mentioned before, a restructure typically involves assets changing hands, and when assets change hands, tax is very much in a hurdle that needs to be overcome. And if the idea is that as the business and the startup gets more and more successful and valuable over time, then kicking the can down the road in terms of the structure results in bigger and bigger and bigger asset values changing hands, and therefore bigger and bigger tax problem. Okay, so even though the ultimate ownership of certain assets may not have changed, even though the original shareholders may still indirectly own the same assets as before, the fact remains that there are assets changing hands, and whenever that happens, there's a tax issue to be resolved. Okay, so certainly earlier is better when it comes to getting to the right structure. And next slide, please. So if you end up in a situation where you do need to restructure, here are some of the common restructures that we see, and these are things that we work on fairly regularly and can comment on. One example is sole traders moving their business into a company structure. Okay, so for the reasons that Helen covered previously in terms of the benefits of a company versus a sole trader. A second common restructure is what's known as top hatting. Okay, so what that means is, let's say you had an original company and for the reasons, for the benefits of having a group structure for the asset protection, or it could be that you want to have different companies doing different things within the group, you would insert a new company above the original company, hence the name top hatting. So what that means is basically that this new company takes over the shares of the original company and is now the holding company. And beneath this new holding company, there could be the original company by itself, or it could be a group of companies and subsidiaries, like the slide that Helen presented a couple of slides ago with 2 operating companies. Okay, so that's a very common one. A third type of restructure may be demerger of one company into separate companies, and this may be because as the company started business, he had more than one business, and over time it's just become apparent that it just makes no sense to have everything in one company, and you want to have different companies, then you would demerge these 2 or more businesses into two companies, and so on and so forth. Okay. Another common restructure is flip up to overseas, and this is actually a form of top hatting. Okay, so and I listed this as a separate restructure because this is flip ups is something that startups often hear about. There are a lot of myths and misconceptions around flip ups, but in effect, a flip up is just simply a form of top hatting where the new company you insert above the original company is just simply a new foreign company, for example, a US company. Okay, so that's a flip up. Now, people do that often when they seek to have a overseas head company because investors demand it, or because they think the exit is in their this overseas jurisdiction. But if all you want to do is access an overseas market, or have access overseas talent employees, maybe just a subsidiary would do. Okay, because a subsidiary, setting up a subsidiary is a lot easier, a lot cheaper, a lot quicker, and a lot more flexible. And finally, we often see a restructure being undertaken because people need to separate corporate and personal assets. Okay, for example, a founder may have ran a business in their previous, gig, and then decided to use the existing company to set up their new startup, and over time it's become apparent that it no longer makes sense to combine the two. Okay, so what are the considerations? What are the accounting, tax, and grant related considerations when it comes to restructures? Okay, so here's a list. Employee share schemes. A lot of the time there may be an existing employee share scheme, okay, which means that if there is a restructure, the previous employee share scheme may need to be tweaked because, for example, the employee share schemes or options may be in a company that is no longer the relevant company that has the relevant assets in the business that the employees are working on. So in those situations, the employee share schemes or option schemes, they need to be tweaked and adjusted and restructured as well. Okay. Early stage innovation company tax incentives, which Helen has mentioned briefly. So that provides investors with a 20% tax offset on the amount of their investment, and also provides capital gains tax free treatment for gains made in years 1 to 10 of the investment. Now, that is affected by certain restructures, but not affected by others. So this is very much an area that if you have an ESIC eligibility or you want to preserve it, then this is something that needs to be considered as part of the restructure. Okay. Thirdly, capital gains tax rollovers and concessions. Now, I've spoken about the risk of tax in unnecessarily applying in a restructure, even though the ultimate owners have not changed. Luckily, there are different types of capital gains tax rollovers and tax concessions that basically either exempt or defer the tax rising in certain restructures. For example, top hatting and flip ups, demergers, sole traders to a company structure. They're all things that can potentially be eligible for one or more tax concessions. And those are quite complex, and we're not going to get into the details today, but it's very much a must in terms of things you consider when you undertake a restructure. So the tax advisor tends to have a say in a lot of business decisions, and especially restructure. So definitely don't go about changing, making assets and shares changing hands unless you first sought a tax opinion on how to do things. Another consideration is when there is a restructure, there's a number of reporting requirements to the ASIC and ATO. Okay, so there are forms that you need to notify ASIC and ATO about. It often gets forgotten, and then later on there's a mop-up that's needed. So my advice is definitely do this sooner rather than later. And finally, R&D tax incentive eligibility. As Helen has pointed out, this is very much a game changer for Aussie tech companies, and to the extent that you're eligible, you want to make the most out of it. A restructure is something that could affect R&D tax incentive eligibility. For example, if assets, for example, IP does not sit where it needs to sit, there may not be an R&D tax incentive eligibility. So you may not be able to get 43.5% back on certain R&D activities. And also a common mistake we see is that there's been some kind of a restructure, for example, top hatting, and the correct taxpayer, the R&D claimant, is not the entity that's listed on the R&D application. So that is something that often gets mistaken and results in a number of issues. At best, it's a cleanup of a massive mess. At worst, it will result in no R&D claim for a year, even though you are otherwise eligible. So this is definitely an area that tax advisor needs to be fully across. Okay. Next slide. When you are undertaking, the idea of an exit is obviously a very big concept in the Australian tech space, because the kind of the stereotypical road to success is a team of people building an awesome tech, and then they get acquired by a big corporate, or they list, or they get bought out by some other company. And so this exit is very much a key consideration whenever you do structuring. Okay, so these are the things to consider. Consider when you intend to exit. Okay, so obviously the timing is important, and there are things you must do well in advance before you actually exit. Okay, for example, getting an audit done on the financial statements, tidying up your legal documents, getting your tax compliance matters and documentation house in order. All right, so they're all things that's going to come out in an exit, in a DD, due diligence of an exit, and if it's not done early enough, it will create a lot of pain during the exit process, and at worst, it could impact on the valuation in an exit. Okay. Think about your international expansion plans. Do you really need that flip up, or will a subsidiary do? Okay, so when you go overseas, if you do use a flip up, then you're really very much hitching your wagon to that overseas jurisdiction, because it's very difficult to flip back. And I've seen it happen, and you're left with a mess in terms of the structure. Think about whether this exit comes in the form of an initial public offering on the stock exchange, or do you sell the IP of the business, or you sell the business itself, or will you be acquired by another company, i.e. a share sale? Okay, so they're all things that are relevant for the structure, because, for example, if you're targeting to be acquired by a major tech company, then you want to be perceived to be nice and bite-sized and have an easy to acquire structure ready to be taken over. Whereas if it's fully entangled into a really messy structure, you are less appealing a target. Finally, think about the number of businesses in the startup. Okay, so what does that mean? I ask people, when exit comes, will the buyer want everything in this structure, or will they say, I only want X, Y, Z, but I don't want A, B, C? Okay, so this goes back to my point about being bite-sized and being an appealing target. Okay, so some of the considerations to think about when it comes to exit. The moral of the story is the work starts early, and it's not something that you can just keep delaying until just before the exit. Okay, all right, that's it. Helen, you might be on mute.
Great, thanks, Jack. Thanks for that content. It was really interesting. It's really important, like Jack mentioned, to think about the end at the beginning. So that really concludes the main part of our webinar. You may find our publication, Startup Manual, a Legal Handbook by Founders, quite useful, which you can download from the handout panel. We also have an upcoming event that may be of interest to you, particularly if you're looking at bringing in talent from overseas. The webinar is on understanding labour agreements and employer sponsorship, which is on Thursday, the 16th of February. So we're going to answer your questions shortly. While you submit them, we'll take a minute to tell you about LegalVision's membership and how you can contact William Buck. LegalVision's membership is a cost-effective alternative to the expensive hourly rates you experience with other law firms. For an affordable monthly fee, you receive cost certainty and an all-exclusive legal services, including unlimited document review, including drafting, amending, and reviewing, business contracts and commercial leases. It includes unlimited advice consultations with our team of 100+ specialist lawyers, including business structuring, employment, disputes, and more, and unlimited domestic trademark registration. LegalVision membership is like having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how our membership can help you, request a free consultation when the survey appears at the end of the webinar. You can also contact Jack from William Buck here through these contact details on this slide. And now we'll answer some of your questions that you've already submitted. So we'll just go through these now. We've got quite a few questions, so we might just answer a few of them. Just keep in mind timing. So if there are any questions that haven't been answered, we'll try to contact you, or as I mentioned, please request a free consultation and we can discuss your questions. So let me have a look here. Did you want to start, Jack?
Yeah, sure. So one question I have is, if you have a company acting as trustee for a discretionary trust, what is the best way to make this attractive to an investor so you can sell out and exit? The answer is you don't, okay? So you don't sell the company as trustee of a discretionary trust. So think of the trustee company and this discretionary trust as almost like a single entity, even though legally it's not. Okay, so Helen can easily point out it's not a single entity. It's basically just think of it as one entity. That's your vehicle for holding your shares in the subsidiary in the startup underneath it. Okay, so you never sell the trustee of a discretionary trust, and if you somehow inadvertently included the startup business in there, then get it out ASAP.
No, I completely agree. Thanks for that, Jack. So I've got a question here. With trust, holding company and operating company structure, can you please expand on the flexibility to expand overseas? So my point in that particular structure was that if you have a holding company, there is flexibility to set up a new subsidiary overseas, which is something that Jack also mentioned as well. If you are venturing overseas or you have investors overseas and they want to have a business, one arm of the business in, for example, the US, then a US subsidiary could be incorporated underneath the holding company. This is a feature that can be done with the holding company structure. If it's in the first structure where it was just the one operating entity, then it would be very difficult to set up a second subsidiary underneath that, because then you'll have two operating entities running vertically, and it may require you to then set up a second subsidiary on its own rather than having it grouped. So that second holding company structure does give you that flexibility to expand overseas, if that's something that is relevant to your business. I do actually have a two-part question here on the holding company structure as well. So the first question is the subsidiaries, if the subsidiaries are 100% owned, is tax consolidation always permitted, or are there conditions to work through this? So one of the requirements is yes, the subsidiaries have to be wholly owned by the head company in order to be tax consolidated. There are certain conditions you have to work through, which is working out the cost base of the assets owned in the operating entity, because you're joining the head company group. That is something an accountant such as Jack can assist with, working out it's called an ACCA calculation, and going through what potentially could be a tax consequence on consolidating. Is there anything further you want to add on that point, Jack?
No, that's cool.
Yeah, okay. And then the second part of that question is, where would the ESOP sit, at a holding company or operating company? So if you were set up the dual company structure, then the ESOP sits in the holding company. The shares have been issued out of the holding company. However, because it's a group, it's a wholly owned group, the employees in the operating entity would be eligible to participate in the employee share option plan, where the employees are receiving options or shares in the holding company. So they work together. And if you were to set up multiple subsidiaries and there were various employees employed out of the various different subsidiaries, that one ESOP plan can apply to that whole group, to each of the subsidiaries. Jack, did you want to take on another question?
Yeah, another question I get is, what are the milestones when a founder or business should look to transition to a more complex structure? So I take that to mean to go from a standalone company to a group structure that Helen has shown in one of the slides. There's no hard and fast rules here, okay? So there's companies that basically start off from day one in a group structure. There's companies that I work with that are, they're doing their Series C, D, whatever, and they're still one company, okay? So, but if I were to give some rules of thumb, it comes down to your personal, to the company's circumstances. Are there a lot of commercial and operating risk that could result in the company getting some kind of an exposure to a big liability to the company? Is there a risk of the company being sued? Is there a risk of something going wrong? If the risks are high, then you want the structure as early as group structure as early as possible. Okay.
Thanks, Jack. I've got another question here about if you've already started as a sole trader, can you convert it and its assets to a corporate entity? It has purchased 75,000 of assets plus IP. So this is when you may need to get advice, or you need to get advice on whether a rollover may apply in order to restructure. I mean, you could restructure and trigger a CGT event, as Jack mentioned, and pay tax on that restructure, or we could see whether one of the rollovers could apply to the restructure. It's provided the ownership stays the same, then there should be a rollover that is applicable. But I would definitely recommend speaking to your advisors, your accountant, to talk through how you can restructure and do this tax efficiently.
And we've got a question, do I need a subsidiary operating company for each country that I want to sell my online app in? The answer is the typical cop-out, it depends, okay? So what the drivers for a overseas subsidiary tend to be both commercial and regulatory, okay? So regulations may require the type of business you're undertaking, that, the customers overseas can only deal with a local company, or they prefer strongly to deal with a local company, or it may be there is no such need, and the customers are happy to directly engage with a overseas, i.e. Australian company. If you need to employ staff overseas, then that tends to be another driver to set up a subsidiary, okay? So basically, it comes down to the commercial drivers and to the tax considerations as well, okay? So this is international tax, hard to generalize, get tax advice.
Tax is very complicated.
Yeah.
So I've got another question here. Do you need to apply for ESIC, or is eligibility automatically triggered through the ATO at raise event, pre-seed or seed stage? So ESIC is a separate topic on its own, really, to be honest. We do actually have a webinar if you're interested on ESIC and qualifying as an ESIC. But in answer to the question, there is no application for an ESIC. It is something that the taxpayer or the company, well, actually the investors, need to determine themselves as to whether the company it's investing in is an ESIC. Most startups would, if they don't qualify for the 100 points test, so there's two tests that can qualify for an ESIC, which is a 100 points test or principles-based test. If the 100 points test is satisfied, then generally that's quite simple and it can be relied upon. I mean, I wouldn't warrant that it's relied upon by the investors, but it's something you can rely on with some sort of certainty, as opposed to the principles-based test, which is really an objective test which needs to be considered in detail, and advice needs to be sought. In most cases, we would advise that the startup applies to the ATO for prior ruling to seek certainty as to whether the company itself is an ESIC. That way, the startup can provide that certainty to its investors, which does make it more attractive to the investor when they're investing. This whether a company is an ESIC needs to be considered every time at the time of when the shares are issued. So it needs to be considered each raise. And if you're issuing SAFEs or convertible note, it's important to note, as I mentioned earlier in the presentation, the timing for an ESIC is not at the time of the issue of SAFEs, but at the time of when those SAFE notes convert into shares. So it's just important to think about.
Okay. Got a question. At a practical level, is it LegalVision or William Buck that could create the family trust holding company or operating companies? That's something that we both do. So contact Helen if you want to get it done. Another question. If the IP is owned by the holding company, how do you mitigate commercial concerns from customers that the holding company will exit the IP licensing arrangement with the operating company, which means that customers will not be able to receive the services? Interesting question, actually. Look, a lot of the time, the customer won't even ask that question, okay? And because they're aware that, you know, yes, that's what the legal agreements say, but then ultimately it is all one business, and they would act in concert with each other. But, you know, if a large customer does ask this kind of question, then there are ways to give them comfort. For example, letting them know that there is a licensing agreement that lasts X number of years, and perhaps giving them assurances around the fact that, you know, it's all part of the same group. Okay. How are we doing for time?
Yeah, we have a couple of minutes. I think we probably can do one more question. Look, as I mentioned, we have an overwhelming amount of questions that have come through. So let me just see. There are quite a few questions about, I guess, what is the right structure. So look, I think if we can't get to your question, I mean, we're not going to get to your question, but definitely book in a free consultation and we can have a chat about your circumstances and see how we can assist. Each, you know, scenario is different. Okay, let me have a look. Okay, so I've got a question here. If there is a holding company, will contracts and employment agreements be under the holding company for all employees under the holding company, or should they be tailored to a specific company letterhead? So in most cases, if you have the holding company and the operating company, the employees would be employed by the operating company. It's actually going to be, it will come down to the trading name and the business name who can use it. So if the you may have a brand that's actually held in the holding company. That brand is likely to be used in the operating company via a licensing arrangement. So the operating company would likely have that brand and the business name in its letterhead. It may be the same name as the operating company name, or the operating company may be trading as that brand name. So it's actually the business name when you register that would be on the letterhead. But in answer to that question, contracts and employment agreements, it would have the operating company name and the trading name of that operating company. So I think that that's all the time we have, unfortunately, to go through all the questions. Like I said, definitely book in if you have further questions or we haven't got to your question. Thank you so much, everyone. I really appreciate your time, and thank you, Jack. Really appreciate everything you've put into this webinar and your time here.
Thanks, everyone. Have a good day.